Good afternoon. I'm Drew Sorrell, and I have the pleasure of leading off. Someone in a different context once told me that it was best to have an audience that was comfortable. I don't think they meant in this particular situation, but I can't imagine a more comfortable audience than one that's unshaven, wearing their pajamas, maybe their shorts, and sitting at their dining room table, at their couch or whatever. So I won't tell you that I'm wearing shorts, but I'm wearing a nice dress shirt, and I will tell you that. I'm batting lead off, and so here we go. Next slide, please. I'm first going to talk about federal immunity. We thought it would be a good idea to let our audience know some of the different protections that do exist for operations during COVID-19. And that starts off with federal immunity. It can be broken down, as we lawyers like to say, into people, things, and contracts. Next slide. With respect to the PrEP Act, this is a people law, or excuse me, a thing law, in the sense that if you are in the business of developing disease-preventing products such as vaccines, or if you're in the process of developing your own respirator, under the PrEP Act, you would enjoy some immunity. And I won't read the slide, but you can see what it says there. Next slide. The Defense Production Act is a contract defense, and it provides for immunity. Basically, what it does is if you have contracts with your current customers or clients to produce and provide to them certain materials, if you agree with the government to provide those materials to the government, which the government has some ability to coerce that compliance, then you have immunity from the breach of contract claim with your customer or client in complying with requirements of the federal government. Next slide. The CARES Act, and you recall I just talked about the PrEP Act. The PrEP Act is the one that provides certain immunities for persons developing respirators and vaccines. The PrEP Act expanded some of, the CARES Act expanded some of the PrEP Act immunities, but it went a little bit further in that it provided immunity for doctors and nurses so long as they're practicing within their specialty to provide health care. Of course, it doesn't cover criminal, reckless, drunken types of activities, but it does exist. Next slide. Finally, if you're a doctor, the Stark Law is probably something you're very familiar with, and this is basically an anti-kickback or self-dealing statute. In this particular case, the Secretary for Health and Human Services has waived for the time being certain what would otherwise be violations of the anti-kickback provisions of the Stark laws. So those exist as well. We've done research. We have not yet been able to find any state analogs to these types of privileges that exist under federal law. I will tell you that the latest news is indicating that Mitch McConnell and the Democratic Party are getting ready to cross swords with respect to the next round of statutes and relief under the question of privilege, with Mitch McConnell and the Republican Party taking the position that there should be immunity for a lot of the different activities that are going on, and then the Democratic Party taking the position that there should not be immunity. Where that's going to play out, I don't have any idea. Obviously, I'm not opining as to which is the right answer to that. I'm just letting you know that the discussion and the fight has begun. Next slide. So let's talk more about what happens when you open your doors to your employees for the first time after about a month and a half. We're all aware of workers' compensation and what it does cover, doesn't cover. Next slide. And if you recall, work comp basically is a strict liability rubric where if an employee gets injured at work, then the employer has the duty of paying for their hospital bills and for their medical treatment to make them well. And so the question arises under work comp, what happens if an employee suffers from COVID-19? Next slide. In the general sense, in what I would call normal times, there would probably not be any coverage under work comp, meaning if an employee got sick at work, if they suffered from what I would call a traditional form of the flu or cold, then usually while there would still be immunity under work comp, there would not, on the other hand, be any coverage to pay for those medical bills under work comp. In this particular instance, it is now unclear as to whether or not work comp would or would not provide protections and payments if a employee gets sick. So here's what that means. There's a 4-part test in Florida that asks what I would call the salient questions, which are, and you can read them, but more or less it's saying, is the disease more prevalent, and is it more likely than not that an employee got sick because of their employment with their employer? And as I said before, with the normal flu, with normal colds, it's usually going to be just as prevalent in the population of the general population than it would be with respect to the employer and the employment. In this particular case, if everybody is sheltering in place and the most, I guess you'd say, touching occurs at work, touching things that are infected or being around people that are infected, then some of the normal testing or the normal legal test for whether or not there's liability kind of goes the other way. There is not, to my knowledge yet, a case in Florida testing this question, but it is an issue. Next slide. Now, I said there wasn't a case in Florida. There, as of about a month ago, is now a case in Aurora, Colorado, which I call the Wando Evans case. Wando Evans worked in a Walmart in Aurora, and he got sick from COVID, and he's passed away at this point. Another worker also has passed away, and then one of the spouses of the worker who passed away has now also passed away. Wando's family brought a lawsuit in tort, not on workers' compensation, alleging all of those bullet points with respect to the conditions at work. Among other things, it suggested in the complaint that the management knew that there were other employees that were sick, that the management knew, obviously, that there were a lot of people moving in and out of the stores, and that the management wasn't providing protective equipment, wasn't providing training, wasn't taking into account all the other employees that were sick, distancing, and so on. So if you look at the Wando Evans case, and if you believe, because again, it's an allegation, not a statement of fact, if you believe all the allegations, then what it suggests is that pretty much this Walmart was not doing anything right. Being a defense attorney, I will suggest that in discovery, some of that will probably be pushed back, but I don't know, there's still a lawsuit pending. So the interesting thing also about the Wando Evans case is that normally you would expect work comp to be the first line of defense. This case was actually filed in tort. The reason I suspect it was filed in tort is because of the first bullet point, which says willful and wanton conduct. What that means in work comp terms is that if there's willful and wanton conduct, then the employer loses the work comp privilege and is then subject to being sued in tort. My guess is the plaintiff's attorney for the Evans estate understood that and wanted to get to the work comp, or wanted to get around the work comp immunities and wanted to get to the pain and suffering damages component that exists in tort but does not exist in work comp. Next slide. The current status of the store is that it's closed, that, like I said, there are 3 persons that have passed away. Obviously, it's a tragic situation, and it'll be months before any final determination is made as to whether or not there was some liability on the part of Walmart with respect to the deceased employee. Next slide. Just so you understand, because I want to now talk about not just employees, but your responsibility as a provider of services to your clients and customers. Like I said, work comp provides strict liability. So if you're injured at work, there's strict liability on the part of the employer has to pay. In a tort, and part of that too is that you also lose in work comp. If you're the plaintiff, you lose the ability to gain what I talked about earlier, which is the pain and suffering damages. It's more or less a compensatory, again, workers' compensation setup where you don't get pain and suffering. On the other hand, in tort, you do get pain and suffering and the damages associated with that. And when you go into tort, it's a question of whether or not you were reasonable in the circumstances. There's not automatic responsibility. And there's a requirement that you prove that whatever the action of, in this case, the employer was, or in this case, the company that's providing the goods or services actually was the proximate cause of the damages. So I'll talk about what that means. And this, again, is my way of transitioning from not what is the employer's responsibility to the employee, so much as it's now talking about what is the employer, in this case, the company's responsibility to its clients. Next slide. So in Florida, there's this concept of business invitees, and that brings you into the question of, well, if you're a business invitee, what then does the business owe you as far as the duty? Next slide. Again, I told you that the duty was one of reasonableness. And so what does reasonableness mean? Next slide. In Florida, it's been interpreted that reasonableness requires a company to provide a warning to its clients and customers of all latent defects. And a latent defect is an unknown defect or one that can't readily be observed. Patent defect, on the other hand, is one that is obvious. And if it's obvious, you don't have a duty to warn. Why am I talking about patent and latent defects? The reason I'm talking about that is because if your employees become sick, if there is some reason to believe that you as a proprietor have an unsafe location or you need to do more cleaning than what you perhaps are, that is probably a latent defect that's not readily observable that there would be a duty to warn your customers and clients about. And I'll explain what that means more in just a minute. Next slide. So here's the issue. If you are a proprietor and if you have customers that come in and see you on a daily basis, picking up food, coming into your hotel, something like that, in a general sense, it would be hard in tort to prove that a customer got sick because of your company. However, if you get into certain fact patterns where you have, for instance, a cluster of employees that you learn have now gotten sick, and you then have 2 or 3 of your customers all get sick, and there is no other reasonable explanation as to where they might have picked up the disease, then that gives rise to the question of whether and if they can prove proximate cause. Proximate cause in this case being, what is the most likely reason for them to be sick? I say all of this because we're in different times. Normally, the question of whether or not somebody has a cold isn't one that a company would worry about. In this particular instance, obviously, it is something you'd worry about because it can be deadly. Next slide, please. And this goes through the technical question as to whether and if there is liability. Next slide. So what does all of that mean? Again, I'm going to tell you. Next slide. Let's talk about Wando Evans again, because he pretty much lays out what this all means. What it means is, with respect to your own employees, you have to engage, and I'll tell you in advance, Maury's going to talk in a little bit more detail about some of the specific employment laws and what they in particular require. However, Wando lays out in pretty good detail what the different issues are. So again, if you're an employer, you need to think about training, cleaning, making sure you've got social distancing, issuing masks, making sure people are using masks, employment screening, and so on before your employees come in. Paying attention to your employees, obviously, is the question there. With respect to your customers and clients, it's the same type of issue. Are you making it so that the clients and customers can be safe if they come into your premises? Are you making sure that they're being safe themselves? Are they wearing masks? Are they cleaning their hands? Obviously, sick people that are coming in should not be served. There should be physical distancing and so on. And so if you look at what the Wando Evans allegations are, as an employer, this is kind of the shorthand for what you should be doing to try and avoid liability. Next slide. And at this point, I'll turn it over to Maury.
Thanks, Drew. Now that you've made the decision to reopen, there are going to be questions about what you can do as an employer, and we'll start exploring them in the next slide, about how you can, for all intent and purposes, limit the opportunities that you will be sued in tort and maximize the likelihood that if you're sued, you will be able to claim the advantages of the workers' comp immunity and limit the claim to workers' comp. Next slide. So what are some of the things that you're going to have to consider as an employer? And these are just some, but the idea would be to give thought to as many of these as possible in advance. How many people are you going to bring back? Are you going to bring back all of your workforce? Or are you going to bring back your workforce in phases? How your return to work plan is. Importantly, how will you identify which employees are coming back to work in what I will call phase 1, 2, or 3, and how will you make those decisions? If you are going to employ immediately less than all of your staff, are you going to expand job descriptions because less people are going to have to do more work? Are you going to assign full-time people to part-time jobs or vice versa? Are you going to permit people to continue to work remotely, or are you going to require that they work only in person? Are their duties, their pay, their responsibilities going to change? Any of these kinds of decisions could expose you to some type of claim. And Rachel and I and Drew have spent, the greater part of 20 or 40 years trying to defend those claims. The more you think about these issues in advance and put together a plan to manage that, the better off your defense will be. Next slide. What are the risks that go with any of these decisions? The ones that we're primarily going to talk about are claims that arise from a discrimination standpoint, an ADA standpoint, or an FLSA standpoint. Whenever you make decisions among your workforce, those are the potentially largest types of claims that you're going to draw, or the most likely claims. Next slide. We suggest that you develop a process for determining who can return. Are you going to enable employees to simply self-certify that they are healthy? Are you going to allow or require temperature checks? If you're going to talk about temperature checks, are you going to administer those yourself through an employee? Are you going to hire a third party to administer the temperature check? What's that contract going to look like? Are you going to maintain records of the temperature check? And what are the issues that potentially grow out of that issue, Rachel?
Yeah, I think with temperature checks, there's a number of different issues there, particularly, well, really to start with, before you implement the temperature checks and decide whether you're going to have one of your own employees handling that or hiring a third party, you'll want to make sure that you've appropriately trained the person, or that the third party is appropriately trained to administer the temperature checks, identifying what is that threshold temperature where someone would have to be sent home. And that's an important issue too, that depending on who in your workforce is going to be administering the temperature checks, or the third party, is that person going to send home your employee, or do they have to alert someone else in a position of authority who will then send the person home? And we're trying to reduce the amount of contact that people have with each other. So it is important to think through these things in advance, and also to make sure that the temperature checkers have the sanitizer and hand washing equipment available for themselves. To the extent that the thermometers have contact with the employee, then those need to be cleaned as well. So as far as record retention, a temperature check, that is medical information, and that is information that needs to be stored in a separate medical file for each employee that is not part of the regular personnel file. So one of the questions that you'll need to answer for yourself when you're determining your return to work plan is whether the temperatures are going to be recorded, whether you're recording simply a pass or fail, or whether you're not recording anything other than that there was, that you administered the protocol, but without actually recording any medical information. But it does need to be stored separately. From an ADA perspective, typically temperature checks would be an impermissible medical exam, unless, of course, and this goes also with the COVID-19 testing, unless, of course, the medical exam is if it's important, if it's necessary for the job. So we're going to look at job necessity. And here, because it would pose a direct threat to the remainder of the workforce, if you had someone who was positive for COVID-19 to come into the workplace, that is why we now have an exception. The EEOC has come out and said that employers may screen. They may take temperatures. They can also require an employee to be tested for COVID-19. And again, that information needs to be maintained in a confidential medical file. And so it is one of those few exceptions. We've had questions about whether other types of testing would be permissible. For example, can we test for the antibody so that we know if an employee in our workplace is at risk of becoming sick, or are they immune? That, however, is likely not permissible, because whether the employee has the antibody or not doesn't have a bearing on whether they are necessarily a direct threat to the workplace. That relates a little bit more to whether the employee potentially could become sick, but that is less about the employee coming into the workplace and bringing the illness in with them. So at the moment, testing for the antibody is not recommended.
And if I could just add too, under tort, one of the things you have to consider is the availability of the necessary equipment to be safe. And unfortunately, if the answer is we can't obtain the equipment that we need to be safe, that's not going to be a reasonable response if there is a lawsuit. Point being, if you say we had to open, but we couldn't do this or that because we couldn't get a hold of the protective equipment, that's not going to justify opening in the absence of the protective equipment. Then I'll draw both of your attention to the question that was just asked in writing, if you'd like to look at that.
Okay, and Madeline, can you advance the slide?
Well, actually, before, I know we're all talking over each other, one final point as well is to make sure that everyone is treated the same from top to bottom. If your company is going to require any type of testing or any type of screening, so the screening could be limited to asking the questions that we now all must answer when we go to the doctor's office, for example. You know, have you had a fever within the last either 24 to 72 hours? Have you traveled on a boat or an airplane or a train? Have you tested positive for COVID-19 in the last 14 days? Have you been exposed to someone? So whether you are screening with those types of questions, taking temperatures, requiring COVID-19 testing, everyone in your workforce who is going to enter your facility needs to be treated the same and go through the same screening. And if they, quote unquote, fail the test, then they need to go home. And that's top to bottom, the most senior person to the least senior person. And that's to avoid, of course, a discrimination claim.
Right. And that's, I saw the question in the Q&A and wanted to get to the next bullet point, which is why I said to advance the screen. But I think that's right. You know, employees who are or might be sick or are caring for someone who can be excluded. They may have to receive the emergency paid sick leave or traditional FMLA, depending on your particular workplace. But as Rachel points out, if someone is ill, they should be asked to leave. And there are other reasons, and you just have to think through these questions in advance so that you have a potential response ready to go when you are confronted with the issue. You're also going to have employees who childcare is necessary because the school is closed, daycare is unavailable. We'll talk later if we have time again about the emergency FMLA provisions related to COVID. And then there's the morale question of what do you do when you have employees who simply fear to return? And if they're employees who have underlying conditions or are of a certain age, you've got questions to consider regarding ADA or other potential exposures under the Age Discrimination Act. They're just potential issues, but go ahead, Rachel.
Yeah, and I think even there, Maury, under the FMLA, if an employee is having anxiety about returning, you have potentially an ADA issue on the one hand, but also the employee might need leave under traditional FMLA if they qualify,
Right.
to care for their own serious health condition, which is anxiety that is preventing them from returning to work. So
Right.
all of the traditional buzzwords that human resources is trained to listen to outside of the COVID-19 paradigm, we need to remember to listen for those. This is not just about emergency paid sick leave or the expanded FMLA leave, or even just about ADA. It's all of the employment laws.
Right.
And
It's the intersection.
If we're sending people home because they're not passing the screening, then that's where the FLSA ties in. Hourly employees, it's different. If they're non-exempt, if they're not working, you don't have to pay them unless they have normal paid leave benefits available, or unless it would trigger the emergency paid sick leave. But if it's an exempt employee and it's not an emergency paid sick leave scenario, then you may still need to pay them their full salary if they worked part of that week before you sent them home. So all of the traditional considerations need to be managed in these situations.
And this is playing off of one of the questions. If you have an employee who is sick and they self-report, or they report before they come in that they're sick, or when they report they have a temperature, what should you do about the other employees that work closely with the now sick employee? Should you monitor them? Should you send them home? Do you have thoughts on that?
I think the most important point is we cannot identify the name of the employee who has tested positive for COVID-19 to the other employees. We can tell the other employees that they either have been exposed or may have been exposed to someone who has tested positive. And then that brings us back to the return to work protocol that we recommend be developed in advance, which is, what do you do in that scenario? So if you believe that you have other employees who have now been exposed to someone with COVID-19, whether it was in the workplace or outside the workplace, does your protocol say that they need to go home for 14 days or they need to leave? And if they are tested and test negative for COVID-19, then they can return sooner. But the idea is to ask those questions for yourselves in advance so that you can anticipate the issues that will come up and then have a plan for how you will manage those.
I agree. I think the worst thing you can do is ignore it or not have a plan that applies to everybody.
Right. And if you have a plan that attempts to distinguish between people and how you respond, that's particularly risky in our opinion, because it will raise the question of discrimination that somebody could assert. Next slide. So you've gotten past the planning and you're preparing to reopen. We've all become familiar with social distancing. In each of your industries, there will be publicly available information, whether it's available from OSHA, from the CDC, from industry-specific groups like Florida Restaurant Association, the American Bar Association, SHRM, whomever, the Florida Department of Professional Responsibility and Licensing. Capture as much information as you can, because as I am prone to say, when you're questioned in a deposition, you want to be able to say, we put together a plan based on recommendations that we got, and that's why we did what we did. Just give thought, read, capture the information, and then make a plan that makes sense in your specific industry, and as we'll talk about in the next slide, in your particular workspace. Make workspace specific, possibly physical changes. Are you going to change conference facilities or reception areas or lunch rooms? Are you going to change the way you sanitize your workspace? Are you going to change staffing levels or go to shifts? Are you going to permit some or none of remote working? how are you going to create a cogent plan based on the available information that's out there? And there is tons of it. And from my perspective, jaundiced though it is, you know, a plaintiff's lawyer in a deposition is simply going to say, well, you could have read this or you could have done that. Did you? And you just have to be prepared to respond to those types of deposition questions later on. So while there are no specific answers on what you should do, I think as a general proposition, it involves reading, capturing information, and making a plan that makes sense in your specific industry and workspace.
And in addition to that, Maury, we're here in Florida, we're primarily used to dealing with potential or avoiding potential claims under the various employment laws. We have less, we have fewer challenges from the union perspective. But one of the issues here is creating these plans and communicating them to your employees so that they feel safe. So actually being safe is half the challenge. Having your employees feeling safe is the other half. And as what we're seeing in other parts of the country are that unions are coming together and threatening strikes because of allegedly potentially unsafe workplaces that don't have PPE available, that aren't providing from their perspective a safe workplace. And so while we don't have many unions here, we have some, what we do want to do is make sure that our employees feel cared for, and that will help avoid a union coming in and saying, you know, you need us because look what happened here during the COVID-19 crisis. Your employer didn't do anything to care for you. And of course, that wouldn't be true. But if the employees feel that way, then there's risk of exposure for the unions to come in.
Right, absolutely. And while I started by saying my goal was to try and calm nervous energy, you know, the National Labor Relations Act actually applies in the non-unionized setting. And it does require even of non-unionized employees, or it permits non-unionized employees to gain protection if what they are concerned about collectively is wages, benefits, and working conditions. And so when an employer starts to hear words that involve we as opposed to me, you have to understand that that language is reflective of the potential for either unionization or for protections flowing to your workforce under the National Labor Relations Act. Any type of collective thought by your workforce gains them that protection. So that's just the way it is.
Building on that just a little bit too, OSHA also has specific anti-retaliation provisions such that if an employee, which by the way, OSHA applies to most employers in the United States,
right,
but the anti-retaliation provisions of the OSH statute or act itself say that if an employee is complaining about safety and workplace safety, if you retaliate against them, which we can all figure out what that means or what the allegations would look like, then that's an actionable problem under the act.
Right. Next slide, Madeline. Just like with social distancing, are you going to supply masks or other protective wear? Are you going to promulgate hand washing rules? Are you going to supply in any form, financial or otherwise, testing? Is it going to be of all positions, of high contact or high risk positions? Is it going to be upon request? Are you never going to do it? Again, just give thought in advance before you open the doors and invite your workforce back to how you're planning to respond to these kinds of issues, and we talked earlier, so there's no reason to go on about what you're going to do if somebody talks to you or is detected of having a fever or a positive test. Are you going to suspend travel? Just things to think about. Next slide. And then, you know, we have a question that's pending about what are you going to do if an employee simply refuses to come back to work? And we'll talk about that issue. But as an employer who's trying to avoid these kinds of issues, we suggest, when possible, to have increased flexibility as it relates to the hours people are working initially, the working location, expressing their concerns about returning to work either too soon because they are either ill or fearful of becoming ill, or you're going to get complaints about people who want to come back to work and weren't selected in the first wave. And why weren't they selected in the first wave? So, you know, you're going to get it from both sides as far as that goes. And, you know, it is important to have given thought in advance to how you're going to respond to the fear of people who don't want to come back too soon. Rachel, did you want to jump in there?
I think it goes back to, I was responding to a similar question in the chat. I mean, it goes back to whether an employee, are we looking at potentially evaluating an ADA issue? Is it a traditional FMLA issue? Is it none of the above, but perhaps the employer would be willing to provide an unpaid leave of absence if there was no regular paid leave available? But because we don't know how long this is going to last, providing an unpaid leave of absence or even a paid leave of absence if an employer is going to be particularly generous for some open-ended period of time carries its own risks. Also, we need the employee to communicate with you. So if an employer isn't, if an employee isn't providing the information that you need to evaluate what you might need to do under one of the employment laws, then at some point it could become a disciplinary issue. But also, as far as morale goes, now that we are looking to return to work, more employees are going to be focusing on what their rights are under these new paid leave laws. So everyone rolled out these paid leave laws, but since many folks were working remotely, they didn't apply at the time, or they might have been not working remotely, but if the business was shut down or no work was available, then the paid leave didn't apply at the moment, but now it might. So while we had a seminar a week ago that went in depth into the paid leave requirements for COVID-19, beginning on the next slide, we're going to do the summary overview of the emergency paid sick leave and the expanded FMLA leave. So as a reminder, emergency paid sick leave is for an employee who cannot work or telework for one of 6 qualifying reasons. The first being that the employee is subject to a governmental quarantine or isolation order related to COVID-19. And for that, they would receive 100% of their pay, although we'll get to that on another slide. So it's if they're subject to a government quarantine or isolation order, if they've been advised by their own healthcare provider to self-quarantine due to COVID-19 concerns, or they're experiencing symptoms of COVID-19 and seeking a medical diagnosis. And I want to pause there for a moment because we were speaking earlier about screening when employees are coming back to work. And if an employee is turned away, you're not letting them into the workplace because they are exhibiting symptoms of COVID-19, then does that automatically entitle them to the emergency paid sick leave? And it seems here that that next step needs to be taken. If you're sending them away because they're experiencing symptoms and then they are going to seek a medical diagnosis, then they would be entitled to the emergency paid sick leave. But if you're sending them away and they're like, I'm not sick, I don't have COVID-19, I'll come back in 14 days, then they wouldn't necessarily be entitled to it. And so from that perspective, it's important to understand what the employee is going to do. Do they need the leave? And we don't want to impose on them what you think they need. So it's important to have that dialogue with them, not necessarily in person, but perhaps by email or over the telephone, because we're minimizing contact to find out what they're going to do, because they've satisfied the first condition, but are they going to satisfy the second of seeking that medical diagnosis? The other three reasons for the emergency paid sick leave is if the employee needs leave because they are caring for another individual who does not need to be a family member, but they're caring for another individual who is subject to a governmental quarantine or isolation order related to COVID-19, or they're caring for an individual who's been advised by their own healthcare provider to self-quarantine. If the employee needs leave because the employee's son or daughter's school or daycare is closed relating to COVID-19, and they need to care for that son or daughter. And then finally, there's the catch-all that at some point the Secretary of Health and Human Services might identify some specifics for another reason for emergency paid sick leave. On the next slide, we're going to review the amount of leave. Full-time employees are entitled to 80 hours of leave, and that's it. If they use the 80 hours for one or more of the reasons, they don't get more time if another reason crops up, another qualifying reason. And full-time in this case is an employee who is normally scheduled to work for 40 or more hours per week. So that is different from the Affordable Care Act or other situations where full-time might be defined as something different. Part-time employees are entitled to the average number of hours worked over a 2-week period, and then we defer to a formula for people with no set schedule. And all of this expires at the moment, December 31st, 2020. So if they use up the time before the end of the year, then they are not entitled to any more emergency paid sick leave. If they don't use it, it does not get paid out to them and it does not roll over to the next year. On the next slide, we'll discuss what they are to be paid. How much is this going to cost your company? If an employee is using emergency paid sick leave for the first 3 qualifying reasons, which all pertain to the employee's own situation, they need leave because they are subject to the quarantine or isolation order, their own healthcare provider recommended that they self-quarantine, or they are experiencing symptoms themselves and seeking a diagnosis, then they get paid full pay at their regular rate of pay, but subject to a cap of $511 per day maximum and $5,110 in the aggregate if an employee were to use all 80 hours. And then if the employee is using emergency paid sick leave for any of the other 3 qualifying reasons, then they're paid at 2/3 their regular rate of pay, subject to $200 per day maximum and $2,000 in the aggregate. On the next slide, we want to mention the small employer exemption for employers that have fewer than 50 employees. They must still provide emergency paid sick leave for reasons 1, 2, and 3 pertaining to the employee's own need, and reason 4 pertaining to the need to care for someone else who is quarantined or advised to self-quarantine, and then that number 6 catch-all. But a small employer could claim an exemption from having to provide emergency paid sick leave if an employee needs it to care for their son or daughter whose school or daycare is closed. There is a notice requirement published by the Department of Labor that must be posted by all employers pertaining to the leave requirements. And then there is also a healthcare provider exclusion that applies to both leave laws, emergency paid sick leave, and the expanded FMLA leave, which Maury will discuss in a moment. And it's a rather broad exclusion that applies to any employee of a healthcare provider, which is broad enough to include hospitals, doctors' offices, senior living facilities, et cetera. So now I'll turn it over to Maury, who will discuss the Emergency Family and Medical Leave Expansion Act.
which applies to employers of 500 or less. It's really employers of 499 employees or less, provided the employee has been with you for 30 calendar days before their need for leave. If the employee was furloughed or laid off after March 1st and returns before December 31st when the law expires, they can again become eligible under the new law. There was a question which I was reading while Rachel was speaking, which says, do these laws apply only to employers with 500 employees or more? And it's very confusing. The expanded sick leave and expanded FMLA apply to employers of 500 or less employees. FMLA, which just requires unpaid leaves of absence, applies to employers of much larger companies and only applies to employers of 50 or more. So there are two ways that you could have to provide FMLA leave. And really there's a question that I wanted, or not a question, a sentiment I wanted to share, which is, the point of our seminar is to encourage everyone to think about these issues in advance and think about how they will respond. But there is no obligation that anybody respond immediately or without additional thought and fact gathering. As former heavyweight champion Mike Tyson once famously said, everybody has a plan until they're punched in the face. Everybody should have a plan of what they're planning to do. And then when you have a specific issue arise, you should take a deep breath. You should gather as many facts as you can. You can see that there are many different permutations and calculations that go into all these issues. And it's not necessary that you respond instantly. So take a breath and we'll figure out what the appropriate response should be. We just wanted to highlight to you all the different ways that these issues will arise. Next slide. The expanded FMLA only applies to an employee, if an employee's son or daughter, school or place of childcare is closed due to COVID-19 precautions. Whereas with emergency sick leave, there are many different qualifying opportunities. There is but one for expanded FMLA. It requires up to 12 weeks of leave. The first 2 weeks is unpaid under this statute. And then the last 10 weeks are paid, capped at $200 a day, or 2/3 of the employee's regular pay if it is less than $200 per day. And that's the exposure under this particular expanded FMLA law set to expire December 31st.
And Maury, I want to jump in for a minute and remind everyone that the emergency paid sick leave and the expanded FMLA leave, those monies should be reimbursed by the government via dollar for dollar payroll tax credits.
Right.
And I am reminding all clients all the time that this is a separate bucket from PPP fund usage. So if your company has received payroll protection program loan proceeds, you cannot use those funds to pay for emergency paid sick leave or the expanded FMLA leave. You can use those funds to pay for normal vacation, sick, or other PTO that you usually provide, but you need to track your emergency paid sick leave and your expanded FMLA leave payments separately. so that you can demonstrate that you used your PPP funds for permissible purposes and that you are separately going to claim tax credits for the funds you spent on the paid leave.
Thanks, and great. Next slide, Madeline. As Rachel mentioned, there are exemptions for the small employer of 50 or less. You can claim an exemption. The way to do that is to prepare in advance a justification detailing why the paid sick leave or paid FMLA would jeopardize the viability of the company. There are regulations that have been promulgated by the Department of Labor of exactly what must be asserted to gain the support of the exemption. You prepare the justification. You do not submit the justification to anyone, but you have it in your file. When someone asks you if they can take advantage of the law and you deny them their request, you keep the denial and the justification and hold on to it if you're ever challenged. You still need to post about the viability or availability of the law. And there are specific steps that you take. We can walk you through those exemptions or that exemption and how to claim it. Or the regulations simply are a roadmap. And then there is the healthcare provider exemption. And if we go to the next slide, I believe it's detailed there. No, it's not. So I will tell you, it is available to all employees of healthcare providers or educational institutions that provide healthcare education, to nursing homes, to home health providers. It is a very broad exemption to anyone in the healthcare industry and all employees affiliated with the employer, and to first responders. Next slide. Oh, go ahead, Drew. Were you going to say something?
I was just going to point out that one of the questions asked was under the record keeping piece, not directly related to this, is whether or not it's okay to use an HRIS system to track the self-certification by the employee of being healthy before they return to work. I thought you just might want to add that in as part of the answer to this.
My sense about it is to capture the information and move it, because I am overly sensitive to the fact that it is probably a medical record at that point and needs to be maintained separate from your other information on that system.
We had two questions, if you don't mind, Maury, that I was going to answer and then invite you and Rachel to fix for me if I screw them up. But the question was, if we decide to bring employees back in waves, do we have to justify to the employees why we chose this person over that person? The short answer to that is no, you do not have to tell them, you simply tell them. Part two of that, this is the gloss, is so long as you, A, don't have a discriminatory reason for why you've chosen to bring this person back versus that person, and then B, you always have to be careful of an unintended discriminatory result. So for instance, if hypothetically one class of persons that you choose to bring back is this particular race and not that particular race, then you have some questions that you might need to be able to defend, which are that we made these choices because of operational functions and so on. The point is you can have a disparate impact by accidentally bringing back a group for a functional reason that is otherwise legitimate, and you just have to be aware of that. Doesn't mean you can't do it, you just have to be careful. Any comments, Maury and Rachel, on that one?
I think you've got it right, that even if you're not announcing to the employees the reasons or the methodology behind the selection, the employer needs to be prepared to defend that it was a legitimate and non-discriminatory or non-retaliatory reason for making those decisions.
And then a somewhat related question, what if the employee is able to work remotely, however the employer is choosing to no longer allow remote work or telework after a given date? And the short answer to that is that the employer has the right to decide how they're going to have employees work. Again, so long as there's not a discriminatory reason, you're not treating people differently for invalid reasons and so on, you can choose to not let people telework. That's up to the employer.
That is correct.
I think that's correct. I think my fear is it will simply become harder for an employer to have a blanket prohibition about no telework when arguably they've just demonstrated that over a period of 6 or 8 or however many weeks, teleworking may well be a reasonable accommodation to a traditional ADA claim. So I think that the overarching advice is right. I just think, you know, be prepared for that battle.
Right, and under the emergency paid sick leave and expanded FMLA leave, while the regulations say that the employer essentially gets to decide whether they're going to allow the remote work or whether remote work is available, Congress is unhappy with that regulation. So while we can go by what the regulation is now, it is possible that it could change, because after the legislation for the paid leave was enacted and the regulation came out, Congress sent a very angry letter to the Department of Labor that said, we don't like that regulation. There are actually a number of regulations they didn't like, but at the moment they're rather employer friendly, so we'll go with it.
Right, and going forward with a view through the rear view mirror, you know, under the ADA, it's a quote, reasonable, close quote, accommodation. And most lawyers would tell you reasonable is a code word for fact specific, which makes summary judgment difficult to obtain, which means it's likely a trial over whether or not the accommodation is reasonable. And thinking of it from a cost perspective, is it worth it to get into that debate? That's a question you're going to have to face moving forward.
Okay. We have a question about what if caring for children is the reason that an employee cannot return to work and their job is not one that can be done remotely? Is the employer required to hold their job until they are able to come back? And is the employee still eligible for employment during that time? So as always, it's a loaded question. If the employee has been employed for at least 30 calendar days by the employer, then this employee is eligible, entitled to the expanded FMLA leave. And that where the first 2 weeks are unpaid unless the employee chooses to use the emergency paid sick leave or their own regular paid leave benefits to get paid during those first 2 weeks. And then they can take up to 10 additional weeks at 2/3 pay. So they're not working, but it is a paid leave. And the employer does need to hold the employee's job so that they can return to the same position or a position with equivalent pay and benefits at the end of the leave. If the employer is a small employer, fewer than 50 employees, then if they make that determination that providing this type of leave would jeopardize the viability of the business as a going concern, then they could deny the leave.
Right. I wanted to answer 2 questions that I've seen pop up. One is it 50 full-time equivalents, or is it 50 employees, or more than 50 employees? The statute talks about employers of 499 or less. 50 employees is the threshold for the exemption for small employers. It is employees, it is not full-time equivalents. And there was another question that asked if I've already paid a few employees emergency leave because we weren't aware we were exempt, would it be discrimination to now impose the exemption? And the answer to that is how you go about doing it. If it comes out later, I would say your claim that you would likely get is, did you apply the exemption discriminatorily, even though you were able to claim it? So it's a question of, did you give an advantage to a group of employees or not to a group of employees in a discriminatory way? You could certainly now start to claim the exemption, but you might be careful of how you go about doing that, because if it turns out that all the employees you previously gave the gave the expanded leave to were young, and now you decided you're not doing it, and everybody to whom you denied the paid leave happens to be protected by the Age Discrimination Act, that may bring you that claim having nothing to do with the real question that you were asking, I suspect. So it's going to be in the application of how you do it.
Well, we're coming up on 2 o'clock, so we'll take another question or two. We did have a question about intermittent leave. For the expanded FMLA, if an employee needs to be absent only 1 day a week to care for their child whose school or daycare is closed, is there a way to calculate eligibility and or use of FMLA? Is it similar to regular FMLA for the birth or adoption of a child? It is exactly the same as regular FMLA, except in this case, you have to pay for the FMLA to care for the child. So similar to traditional FMLA, if the employer and employee both agree that intermittent leave can be taken to care for the child, then that works out, then you're permitted to do that. And you just need to track it as such so that they're paid for, so that the hours that are expanded FMLA leave hours are paid at 2/3 of the rate. And then the hours that they're working, they're paid at their full pay.
Well, thank you very much for attending. We hope we've answered most of the questions that you posed. We certainly would be happy to talk with you if you have more. As you heard, we will circulate the PowerPoint presentation in a couple days. Thank you again for coming.
Thank you.